Thanks for joining me, Shane McNeill, as we talk about powers of an attorney. A power of an attorney is simply where you appoint an agent, or sometimes called an attorney in fact, to take care of business on your behalf. A power of an attorney has broad authority in most situations, depending upon a document that you give this person. A power of attorney can give one the power to buy and sell things, to invest money, to collect debts, or even sue on your behalf, among a list of other things that can be done with it. What it cannot do, however, is make or alter a will, or an agent cannot place your vote in a public election. Who should have a power of an attorney? Well, pretty much anyone. That's probably the easiest answer, but those that are particularly interested are those who need a power of an attorney for convenience. If they need someone to take their place on a transaction, say a real estate transaction, buying a car, then that person can appoint another person to do that for them. Another reason why you would consider a power of an attorney is for planning in the future, for an event such as an incapacitation or a mental illness, or anything that would mark you disabled, incapacitated in order to take care of your own business. If you don't have a power of an attorney, a court can step in and appoint a conservator or a guardian for you. The problem with that is that it can be a very expensive process and can take years. We can look at a case that was about 10 to 15 years ago in the matter of a songwriter in Nashville, Danny Tate. Danny Tate had roughly a $2 million estate, and his brother filed to be a conservator over his estate. At the time, Danny was receiving about $25,000 a quarter for songwriting royalties. Well, the process took on several years. Danny fought the conservatorship and eventually was released from the conservatorship. But in the meantime, the attorneys on both sides ended up billing more than $215,000 in legal fees. A court in Louisiana in 1963, I think, said it best, says that a judgment of interdiction is, in the final analysis, a pronouncement of civil death without the dubious advantage of an inscription on a tombstone. There are four main types of power of an attorney that you should be aware of. One is a general power of an attorney, which gives broad powers and ceases upon the principal becoming incapacitated. There is a limited power of an attorney that grants an agent specific powers to conduct specific matters on behalf of the principal. You have a durable power of an attorney, much like the general, except that it sustains an incapacitation of the principal, meaning that it carries on. Another one is a springing power of an attorney. A springing power of an attorney begins on a specific event occurring. That could be turning a certain age, it could be a specified date, or it can be upon the incapacitation of the principal. If you find this information helpful, I'd appreciate a small contribution on Venmo. You can find me at SK McNeill, that's with 2 L's, and also telluslaw.com. Thank you.